Welcome, everyone, to another edition of our California Conversations series through the California Arbitration Association. I'm delighted to be here with my good friend, Ken. Now, this is a little bit of a ringer situation because Ken and I are co-chairs of the marketing committee. So we're good buddies here. It's not like I'm going to be asking a lot of questions of Ken, and we've never met each other. So I'm coming from a blank piece of paper. But I'm delighted to get a chance to chat with Ken and learn a bit more about his practice. I'm sure I'm going to learn a lot of things, Ken, that I didn't know about you already. So thank you so much for taking the time. I really appreciate it.
Well, thank you for doing this.
Great. All right. Well, why don't we start out? Tell us a little bit about yourself. What's been your professional path and lead up to now and your current practice and sort of what cases you specialize in. So please.
Yeah, right after law school, I worked for a federal judge as a judicial law clerk, and then I moved to U.S. Attorney's Office. I served as a federal prosecutor doing mostly guns and drugs.
Amazing.
Yeah, and then I thought that might be something that I'd be doing for a long period of time.
Well, I'm going to take you back a little bit further. You went to Cornell undergrad and you got a degree in electrical engineering, right?
That's right.
And then law school at Northwestern.
Exactly.
And then you clerked for a judge and then became a federal prosecutor. So, wow, guns and drugs, that's intense. That's some pretty hardcore work. So that's amazing. So, okay. And then what was your path after that?
Then I came to Silicon Valley and started practicing patent litigation. So it's kind of funny because I handle a lot of employment cases when I was a law clerk to a federal judge. So when I came to Silicon Valley, I actually applied to a couple of firms that do employment law as an associate, but then those firms also did patent litigation. I went to interview at Wilson Sonsini. As soon as the partner found out I actually have an electrical engineering degree, he says, wait a second, you're going to apply as an employment associate? No way. He said, you sit here, and then they changed all my interview schedule with the patent litigator.
Wow, see, you can't escape the engineering degree.
Exactly.
Yeah, that made you a unique quality.
Yeah. So that's why I had to work as a patent litigation associate.
That's great. That's great.
Yeah. And then after that, I practiced patent litigation for next 10, 12 years straight. But then one day, one of my clients came and asked me for help with the patent transaction work. What that was that they were trying to buy a patent portfolio from a company whose only asset was patent portfolio. So they need someone to evaluate the patent portfolio. I figured that's what I do as part of patent litigation. I said, well, why not? That's how I got into transaction business. And then that grew into a technology-focused M&A practice.
Wow.
So at some point, I decided to leave a big law because I really didn't need their big platform. I formed my own
boutique
known as a Capria. And that's when I did a lot of acquisitions. I did a lot of patent licensing, and that led me to join Samsung Electronics, first as a VP and later as a senior VP of Silicon Valley IP office.
Wow.
And I thought I was going to do a lot of transaction, and I did. I acquired several startups in semiconductor space as well as display space.
Well, here in Silicon Valley, Samsung is famous for their large IP portfolio. So that's a big remit to manage all of that and acquire all of that IP too. So that must have been an amazing job.
Oh yeah, one thing I'm really proud of is that I acquired this company called the Clairvoyant, and they had this Pentel technology. Important thing about that is that it allows smartphones to use organic LED screen. All the high-end smartphones nowadays have OLED screen.
That's right.
It's brighter, it had give you a better resolution. The issue was that it was using too much battery. So you couldn't use it on battery-held devices such as smartphones.
Sure.
Intel technology reduced the power consumption of OLED. Wow. So when I bought that company on behalf of Samsung. That technology got incorporated into literally hundreds of millions of smartphones.
Amazing,
And
amazing.
now, whether you have a Samsung phone or iPhone, you're going to have that OLED screen on your phone.
That's great. That's great. It's amazing to go back to that one acquisition and think, I changed the world. All of these hundreds of millions of phones that people are carrying around the world were changed by that deal that you put together. That's cool.
Yeah. But then I thought I was going to be in transactional work. But Apple had different idea. As soon as I joined Samsung, Apple sued Samsung.
Right.
So I got dragged back into patent litigation, which lasted about 7 years. It was a monster of a case.
That's
It
where
generated,
billions and billions. That was a huge, legendary case in the Valley. Yeah.
yeah, it really was. It ended up generating about 50 actions in 10 different jurisdictions around
My
the world.
goodness. Wow.
Yeah. Yeah, but I did plenty of transaction work along with litigation. I handled several hundred patent transactions, as well as personally negotiating three of the largest patent cross licenses.
Wow.
Two of them are public, so I can disclose that was with the Cisco, and the other one was with the Google.
Wow.
And I ended up getting involved with acquisition of Fortune 500 company.
Wow.
And then I guess I was in a particular period where we had patent litigation kept going up and up. So I ended up, I guess, handling about 700 patent litigation. I had about 4 litigator under me, and I guess I supervised rather than.
I was about to say you had lots of outside counsel that were doing a lot of the work in the trenches, but you had to supervise all of them. Yeah. Amazing. Wow.
Yeah.
That's incredible. So what was the path after leaving Samsung?
Yeah, so I knew that Samsung was not going to be last chapter in my professional career. So I was thinking that what is that I really want to do after Samsung? And I realized that throughout my entire career, I was fighting. As a litigator, I was fighting. Even as transactional attorneys, you're really fighting with the other side. And when you negotiate licenses, undercurrent is that if we don't do this deal, there will be a litigation. So instead of fighting, I wanted to make peace. And that's why I chose mediation and arbitration. To a degree, I guess it's a private way of ending a dispute. So that's why I got into ADR. I took some courses, and then when I left Samsung, I applied to San Francisco Superior Court as a settlement conference officer.
Great.
And they accepted me into their panel, and that's how I started doing mediation. And I've been doing mediation and arbitration ever since.
That's great. And you do FINRA cases, you do WIPO cases. I know you're all over the place, handling different kinds of matters. So why don't you tell me a little bit, like, what is your philosophy as a dispute resolver? How do you see your role when you get involved with a case as a dispute resolver?
Yeah, as a mediator, when I get involved in the case, I know my job is to settle the case. It doesn't really matter what parties tell me. I've been told by many parties during mediation that that's it. We are done talking. We're walking. But I always remember whenever any one of my parties tell me that they're ready to walk, I remember my job is to settle the case. So I keep talking. It's like, I understand you're upset, you're frustrated. I would be if I were you. But why don't we make this offer to the other side? So, maybe that will make them more reasonable. You got to be kidding me, but maybe I should listen to you. I'll let you sort of fool me one more time. and then, incredibly, I think people really want to settle. I mean, people did not call me just to walk away from mediation.
Sure.
They called me because they actually want to settle the case. And my job is find that middle ground, which make people comfortable enough for them to settle the case.
Well, it's interesting. I think we've seen over the past decade the rise in evaluative mediation. And so your expertise is so incredible. I mean, you've been involved with so many of these cases. I could see the parties wanting to know your opinion, and as you say, like maybe put together a mediator's brief, or do you do evaluative mediations, or is your style more facilitative?
Mine is definitely evaluative.
Mm,
Well, I try to give good sense of my reading of the strength and weaknesses of both sides cases, or sometimes more than two. And then I'm trying to facilitate a settlement on the basis of the strength and weakness of the cases.
mhm,
Because any litigation, you need evidence to support your case. So we need to have a fulsome discussion of the evidence supporting each side claims or defenses, and then on that basis, we can talk about how we can carve out path from there. And oftentimes, it is really difference of opinion on valuation.
mm,
Every mediation is exercised on evaluation.
mhm,
People think that based on evidence, based on the facts they know, that they think the value of their case should be this,
mhm.
and which the other side will probably disagree. So my job is bring that valuation in the ballpark, so they will be able to say, okay, for that, I think we are ready to settle. And also, this is how I explain to the parties is that don't worry about how this settlement is going to do to the other party. Just focus on yourself.
Mhm.
Focus on the risk you're facing, how much it's going to cost you to hedge that risk, and then figure out for yourself whether the money that takes to get rid of that risk is that, how does that compare to your next best alternative,
Mhm.
which typically is a litigation. If you think that money you have to pay today, or money you are going to accept today to give up your claim is better than the alternative you have, then you should take the deal. And oftentimes, if you have a co-defendant, just remember they're contributing to the settlement. Or if you're plaintiff, it's always easier when there are two defendants who are sharing in the settlement. So don't give up on today's settlement, thinking you're going to do better, because today is a day where you can actually cut the best deal possible for yourself.
That's great. Wow, that's great. I can already, I'm feeling already, Ken, how great you'd be in the heat of a mediation. But so let me shift it a little bit closer to arbitration. Have you ever done any medarb?
No, there was one time where parties asked me to do mid-arb, and I thought about it, and I said to myself, I'd love to do it, but I don't think it's fair to the parties, because during mediation they're going to tell me all their confidential information, and I'm
Right.
supposed to make a decision. As an arbitrator, I'll have so much leverage over these guys. It's
Hmm.
not fair, but I do something close to that in mediation,
Hmm.
which is a mediator's proposal. It's non-binding, but when parties are still quite a bit apart at the end of the day,
Hmm.
after 4 hours, after 8 hours of mediation, you know, they're still apart. And then if they turn to me and ask me to make mediator's proposal, that's a time I can put together all the evidence and all the things I heard from both sides,
Hmm.
and put together a proposal that I think will be acceptable to both sides begrudgingly.
Well, I'm with you. I think there are people that are, practiced practitioners of MEDAR, but there's a lot of fraught. If you're really engaging in a mediation and seeing all the negotiation back and forth, it's really tricky to say, okay, well, now I'm going to put the arbitrator hat on, unless you've known that that's a possibility all the way along. So now let's talk about your experience in arbitration. So you've been involved in some really big arbitrations. I mean, both on the counsel side and on the arbitration side. So tell us some more stories. What are some of the arbitrations you've been involved with?
Yeah, so I've been involved with patent related arbitration. I guess the patent arbitrations are not very common because patent bar is not used to arbitration. They're not comfortable with it.
Mm-hmm.
And that's why we don't see a lot of patent arbitration. But I've been fortunate to be involved with some of the biggest patent arbitration cases out there. There's
Mm-hmm.
one case I was involved Ads Council a couple of years ago. It was a multi-billion dollars in claims, and that was very exciting. And it involved some of the largest companies in the world in the telecom space. I'm actually involved in another one just like that, and similar issues. And I'm thinking that arbitration might be more prevalent in patent fields going forward. I'm
Mm,
already hearing from my friends that they're getting involved more and more patent arbitrations. And part of the reason is that, you know, patent world is probably getting, yeah, at least in particular areas such as FRAND, which stands for fair, reasonable, and non-discriminatory licensing obligations
mm,
under this special kind of patents called SEPs, Standard Essential Patents. The problem with the Standard Essential Patents are the they read on global standards. So that commitment applies to a company's global patent portfolios, whereas patent issues are supposed to be handled by national courts. But you have a bunch of national courts want to resolve the dispute involving global commitment, then you have a fracturing of case law from country to country. That's what's going on with SEP or FRIEND, part of patent world. So I think the international arbitration makes sense because now instead of having to deal with each country having its own case law, you go one place where you can resolve all the disputes by same tribunal rather than having to have a multiple parallel proceedings in many different countries. So I think that's sort of going to be the trend, but we shall see.
fascinating. That's interesting. And so the cases that you've been involved with as an arbitrator, have they been these kinds of cases, the friend cases?
No, I've been involved not only patent arbitrations, but I've been involved with the commercial and consumer cases. I
Oh,
love consumer
interesting.
cases actually.
Okay, yeah,
Because
that's
if you think about it, now we are all consumers, and when we buy products or when we buy services or when we sign up for membership, I think more than almost all those agreements will have an arbitration clause. So when you
absolutely.
have issue with that company's product or services, and you trying to bring a complaint, you will actually have to file an arbitration complaint.
Mhm,
So,
mhm.
and I'm handling some of those cases. This is really fascinating.
Yeah. Well, I've dealt with a lot of consumer issues too, and I know it can be tricky. The whole notion of consumer pre-dispute binding consumer arbitration is very controversial around the world. I mean, in the US, you're right, it's very commonplace. Pretty much any cell phone
Mhm.
contract, banking contract, you're going to have those arbitration clauses. But in other regions, it's illegal to actually bind consumers in those
Mhm.
mechanisms. So in the consumer arbitrations that you've done, there's always a presumption that the business holds the upper hand in arbitration with consumers. What's your experience?
Yeah, I heard that comments, and more than one the consumer's attorneys told me that it is unfair that she has to be in front of me, the arbitrator, because it was a click-through agreement. My client really did not have a chance to read,
Right.
and he did not know what he was giving up. Well, the case law, at least in the United States, is that it doesn't really matter. If
Mhm.
you click that button and you agree to terms and conditions, then you have agreed to terms and conditions. I can see why the consumers may or more like their attorneys feel like this is not fair. I get that,
Mhm.
but you know that's the world we live in,
Mhm.
and it is also convenient that we will be able to enter into a contract that way. And so I get that, but at the end of the day, you need to look at what the terms that consumer has agreed to and the company has provide for, and see whether that arbitration clause covers the claim. That's the one of many issues you have to decide is arbitrability.
Right.
And sometimes usually you get interesting fact patterns because if dispute is one of the cookie cutter chances are they probably will settle it. Once they ended up coming for a decision, they tend to have interesting fact patterns.
Right. Absolutely. Yeah, I mean, I think you're 100% right about that. The low-hanging fruit cases are going to get worked out before they make it to you.
Mm-hmm.
You know, the only case that's going to get to an arbitration, there's got to be some knotty issues that need to be untied.
Mm-hmm.
So, yeah, that's an interesting one. Well, you know, I mentioned before that you're on the WIPO panel. You know, I've done a lot of domain name disputes
Mm-hmm.
through the UDRP, the Uniform Domain Name Dispute Resolution Protocol. And it's interesting to think about the UDRP for domain name disputes because it's kind of a world court. You know,
Mm-hmm.
it's like anyone who buys a domain name, you agree to resolve the dispute over that domain name should one arise in this Uniform Domain Name Dispute resolution process. And I think it's sort of a model for the future, you know, as the internet doesn't really care about borders. You know,
Mm-hmm.
when you engage in a transaction, you could be anywhere in the world. You know, you could buy a .com domain in any country, anywhere. So it
Yeah.
doesn't really matter what your home jurisdiction is. And I think that that's an interesting way to think about the future of arbitration too. Are we going to be creating more of these globalized mechanisms for resolving consumer disputes? Because any of us can pull our phone out and swipe, swipe, swipe. We can buy something from someone on the other side of the planet. Trying to figure out what jurisdiction applies and what's the venue for resolution. You know, if the buyer is in America and the seller's in Europe and the items being shipped out of Asia, you know, it's just figuring out the jurisdiction is going to be hopelessly complicated. So it seems like that consumer arbitration mechanism you're talking about is a better fit with disputes moving forward. Yeah.
Yeah, I think you hit it on the nail because and hit the nail on the head. I'm sorry, because one, I guess the next development is a metaverse, and a lot of people are predicting that metaverse will become much more prevalent. They'll be interconnected, just like internet, and
Right.
that creates similar issues like domain name, because what is the territorial limit of metaverse? There isn't any.
That's right.
Yeah.
That's right. Yeah, you wrote a great article about that for arbitrate.com. I know that you've been thinking a lot about the metaverse. So where do you think this is all headed?
Yeah, I think the dispute involving metaverse got to be based on the UDRP, how we resolve the domain name disputes, because we are essentially dealing with the same kind of fact patterns. You have a nationless environment where people from many different parts of the world will participate.
Mm-hmm.
And if they have the disputes, national law is probably not going to be enough. I mean, yeah, it's kind of like ironic that in this day and age, if you want to sue somebody, you have to locate where that person lives. You have to hire local counsel. Let's say the person lives, continents away.
Right. Right.
Yeah. And oftentimes it's, let's say, one consumer having another issue with another consumer. Let's say I think the metaverse harassment, just like that harassment is becoming a big problem.
Mm-hmm.
But how do you locate that person? Even if you locate that person, how are you going to serve processes on that person and have the litigation initiated? So we need a better way of resolving disputes. And I think the domain name disputes actually point out better way to do it rather than relying on national courts.
Sure. Yeah, I mean, it's been running for decades and it seems like it's a trustworthy mechanism. But I remember I did some dispute systems design for an early metaverse company called Second Life. And they were run by Linden Labs. And it kind of goes back to what you were talking about before, because they had a very liberal interpretation of intellectual property. So people in those metaverses, they could create clothes, they could create items, they had the ability to invent things. And Linden Labs said they own the IP. So, as you say, if we have a redress and resolution process that's dependent on geography, but people are interacting in a virtual space where geography is meaningless, that's a tricky thing. You may be communicating with somebody from Russia or from Indonesia, and it looks like they're just right next to you, and you interact with them every day. So I think we need to separate geography from how we resolve these disputes.
Yeah, remember we were talking about FRAND obligation and how
Right.
that is a global obligation, and if to the extent the players in that space start start relying on international arbitration to resolve their conflicts,
Mhm.
then we may actually develop a separate case law apart from national courts, and that deals with friend obligations. And if that model grows, then why not? Yeah, we can actually have a separate private case law involving IPs. Of course, we have to
Sure.
deal with the confidentiality of those decisions,
Mhm.
but if there's a will, there's a way.
Well, and there's a lot of talk now about NFTs, and could we
Mhm,
use blockchain as a means of protecting, building a global IP protection process? Because,
mhm.
you could essentially create an NFT and then put it on the blockchain, and then that would be the way you would establish ownership over IP versus filing in all of these individual
Mhm.
geographies. So, there could be some pretty inventive rethinkings of the way we protect intellectual property moving forward.
Yeah, you're right. I mean, the blockchain, right now we have this crypto currency. I guess yeah, I guess a lot of people are enthusiastic about cryptocurrency,
Mhm.
but that's just one aspect of blockchain technology. The biggest advantage of blockchain technology is that it can ensure that whatever the record that it is associated with is going to be essentially tamper-proof. It's going to be a very secure way of keeping track of the records. So I like that. We are actually using core strength of blockchain technology to address problems that we have right now, rather than using it for financial speculation. So I like that.
Oh, that's great. That's great.
Mhm.
Well, another thing that's very hot in Silicon Valley right now is artificial intelligence. I
Mhm.
think ChatGPT 3 has just come out, and now Google is releasing their competitor, and Meta is thinking about releasing their competitor. It has very interesting ramifications for
Mhm.
IP, and I think there are artists and musicians who are claiming infringement because a lot of these algorithms are searching their content and learning from their original inspiring works, and now it's generating new output, but that new output couldn't exist without the prior. So there's going to be a lot of interesting questions we have to address in terms of IP and patents, in an era of algorithmic intelligence that's sort of remixing our culture in front of our very eyes. So that'll be very interesting.
Yeah. I mean, right now I teach technology licensing at Santa Clara University Law School.
Mm.
And one of the things I have to prepare for is final exam. And I'm going to make it a drafting exercise, but I'm just wondering whether my students will use these AI tools
Right.
to write the agreements, draft the agreements for themselves rather than drafting them themselves. So that's yeah, even I didn't realize I was gonna have to think through the ramification of all these new AI tools, because it will directly impact my final exam.
Absolutely, absolutely. Young Bronco lawyers, you heard it here first. You have a preview of what your final exam is going to be. So, yeah.
Don't
Well,
use a chat GPT.
don't use ChatGPT. Exactly. Well, the other thing is, do you think we're ever going to see AI-based arbitrators and mediators? Where we would. I mean, you said a big part of your job as a mediator is saying, well, what's the value of this case? And
Yeah.
I mean, I could see an algorithm, much like ChatGPT, saying, well, I went out and looked at a million similar cases, and I think my estimation as an AI of the value of your case
Yeah.
is this. I mean, do you think that that's going to happen in our lifetimes?
I think AI tools can be useful for evaluation, but I think the in many mediation, you do have to address the human component to it,
Mhm.
emotion. Sometimes emotion is driving one side's perception of valuation.
Mhm.
So that's one thing that AI probably is not well suited to deal with, human
Mhm.
emotion. So I think the AI tools will be useful for mediation, but I don't think it's going to replace mediator. And for similar reasons, it's not going to replace arbitrator.
Absolutely. Well, we talk a lot in the online dispute resolution field about technology as the fourth party. So party one and party two are the disputants. Party three is the human neutral, the mediator or the arbitrator. And then the fourth party is technology. And the fourth party and the third party, they are partners. You
Mhm.
don't want to just turn over the process to the fourth party. but you also just don't want to have a third party that can't get access to the capabilities and the tools of the fourth party. So I think you're right. I think that the human component of dispute resolution is not going away anytime soon. Making sure that people feel heard, being able to reframe, being able to exercise judgment. But I think that we're going to start to see the use of these AI-based tools. It's going to become more and more common moving forward. Yeah.
Yeah, I mean, one example is that the other day I was having mediation and two sides trying to tell me that plaintiff did not produce this or that. And I was thinking, and luckily for me, I read everything. I essentially memorized some of the exhibits, but they're trying to tell me we didn't get that information. I said, no, it's there. Look it up. It's in the exhibit. And they put 40-page supporting documents. They did calculate the damages, and you can actually verify whether their calculation is correct or not against that supporting evidence. And so they sort of, after that, they kind of looked at it and said, okay, well, we'll drop that argument. Now, with the proper AI tools, I probably don't have to get into that kind of conversation.
Right.
Yeah.
And very interesting. Very interesting.
Yeah.
Well, this is great. I mean, Ken, thank you so much for this conversation. It's fascinating. I've got a million other things that I'd love to talk to you about. One last thing that I'll ask you about, and I mentioned this before, I'm very interested in technology transfer from universities, researchers to the private sector. And I know you've done some work in that area. And I know that could be a very fraught process of figuring out how, which technologies emerge and sort of how they get licensed. Have you seen any dispute resolution around cases like that? And do you know, like, what are the common types of misunderstanding that can emerge in those types of transactions?
Well, so universities, they tend to do basic research. So when university license out their technology, usually with patent licensing or trade secret licensing, they're hoping that people will take their basic research and then productize that basic research.
Sure, turn it into applied research. Yeah.
So I think sometimes universities get frustrated because they don't think that they're getting proper compensation for their basic research. And it really kind of depends on the fields. And the life science, their research is more than just simple basic research. So a lot of pharmaceuticals, medical devices companies work closely with the universities. And I think on that part, relationships seems to be a lot more satisfactory to both sides. Whereas in the IT space, I've seen some tensions because there's some gap between what university has done and what companies have to do in order to turn that into products and services that can sell and generate royalties for the universities. Or sometimes, like, for example, a good example is that nanotech. Maybe 10 years ago, nanotech was the rage. And one point I got involved, like maybe a stretch of 3 or 4 years, where I bought a whole bunch of failed nanotech companies and their portfolios. And they're all like saying that, like we burned through about a couple $100 million in this in this technology. I think we are kind of chasing for the solution that nobody actually wanted. So that can be nanotech. Don't get me wrong; it's a cool technology. It's I think it has a lot of future. It's just that the timing was not right. So that's the sort of business level disagreements or business level issues with tech transfer. But universities have a lot of tools as the patent owner. When you don't actually have to give exclusive license. If you do give exclusive license, you want to make sure you have like milestone expectations, and the companies that license your technology have to meet that milestone goals. Otherwise, they might lose license, or license might become exclusive to non-exclusive. And then there are royalty requirements. you can definitely put minimum royalties. So that will give further incentive to companies. It's not they're just missing milestone goals, but but every year they have to make minimum royalty payments, whether they sell products or not. So that also give them an incentive to hurry up the process, so they'll actually have a revenue from which they can pay the royalties.
Interesting.
So there are tools you can use, and it is a field where there's a lot of discussions and a lot of licensing going on right now.
Yeah, I did a project when I was at Harvard with the Office of Trademark and Technology Licensing. And there was a researcher who had come up with, I think it was carbon fibers. It was a very innovative approach. But as you said, it was very basic research. And they filed a patent on it, but no one licensed it because nobody really understood, well, what's this? How would this be useful? I mean, it wasn't applied. And then it turns out a few years later, a French researcher came up with a different technique, but to make similar, and they successfully licensed it to industry and it took off. And this person at Harvard who had created the technology, they were very frustrated because none of the licensors understood the value of it. But I think it gets to exactly what you said. It's this gulf between basic research and applied research. And the researcher says, well, this could change the world. But if a company doesn't see how they're going to make use of it, then they're going to undervalue that technology. They're going to buy it on the cheap because they're like, well, I don't know if anybody's ever going to buy this. So it's a fascinating space. I'd like to learn more about it, and your experience is really interesting.
Yeah. I mean, the thing is that it's, in order to have a powerful patent, it has to cover products or services that are being offered in the marketplace, because a patent right is granted as a right to exclude others from practicing patented invention.
Right.
So the thing is that the tricky part is that if you have patents on basic result of basic research, such as materials, it's kind of hard to have enough claims to cover all different permutation of that materials that will later be used in the industry. So you gotta have, if you don't have that, even if you're the one who invented the material, later that somebody else figure out how to incorporate that material into different products, and if you don't have that, if you have missing elements to cover that product, you may not be able to enforce your patent rights. So that's where a lot of dissatisfaction comes. But I think Technology Transfer Office should play an active role to trying to bridge the gap. So
fascinating. Well, I could talk to you about this all day, but I just wanted to thank you, Ken. This was a great discussion. I'm honored to be your co-chair on the marketing committee. I think we're doing great work. There's a lot of exciting developments that we've been discussing that we'll be bringing to California arbitration soon. But is there anything else you'd like to say in terms of wrapping us up today?
Well, I really appreciate you doing this interview for California arbitration. I think we live in a fascinating world, but it is also a very complicated world, and that's why we have a lot of disputes. And I think the ADR professionals, mediators, and arbitrators are needed more than ever, because our court system is clogged with so many cases. And in order for people to interface with each other with as little friction points as possible, I think the mediators and arbitrators are doing a fascinating and very essential job of resolving those conflicts. Amen,
brother. You're preaching to the choir. I couldn't agree more. So thank you very much, Ken. This was a great conversation. I really enjoyed it. And thank you to everyone for joining us.
Okay, thank you.